Phil Silberman with the Silberman Law Firm here today, and we are going to go over Texas intestacy. Basically, what happens if you don't have a will in Texas, and who gets what heirs get what things. So let's go ahead and get started. What we have on the screen today is a chart entitled Texas Descent and Distribution. And if you're an attorney that works for my firm, you likely have been handed this out when you started working at the firm. It's a quick desk reference when someone dies without a will and you're trying to explain to a client what assets the client or the heirs of the decedent are going to inherit. This chart, this intestacy chart, is actually put out by Probate Court 1 in Harris County. It's something that we've used as a quick reference for years. It doesn't cover every intestacy situation, but it covers 99% of the intestacy situations in Texas. And you notice that it references the various sections. TEC stands for Texas Estate Code with the section. So let's go ahead and go through it briefly with some of the common situations. The first section deals with a married person that dies with children. Section A deals with the separate property when a married person dies with children. Section B deals with the community property when a married person dies with children, where it's a nuclear family situation and all the children of the decedent and the children of the spouse are one and the same. There are no children outside of the marriage. And then the other section B of community property only applies where the decedent had children outside of the marriage, not from their surviving spouse. So first you need to know the difference between separate property and community property. In Texas, separate property are usually things, real estate or assets that have been inherited by someone, in this case, inherited by the decedent, gifted to the decedent, or owned by the decedent prior to marriage, or contractually made separate property pursuant to a postnuptial agreement or even a prenuptial agreement. Also, the postnuptial agreement is also known as a partition and exchange agreement. So those are the main sources of separate property. For spouses that die with separate property, the real estate section's over here on the left in red, and the community all other properties over here in yellow. So for real estate, separate property, married person with children, the children are going to get the remainder interest, the good stuff. When that surviving spouse dies, the children will own all of it, but that's going to be subject to a surviving spouse's life estate in 1/3 of basically what they call a 1/3 life estate. That's extremely difficult to quantify in Texas, but you need to know if you're a surviving spouse and your deceased spouse owns separate property, then you have a 1/3 life estate, which is some type of economic interest. Additionally, and it doesn't say this on the chart, but if the property was homestead property, you also have a spousal homestead right, which allows you to live in the property, and that arises out of the Texas Constitution. All other property, personal property, separate property that belong to the deceased spouse, the children are going to take 2/3, and the surviving spouse will get 1/3. And then the next situation is the nuclear family situation. So all children, husband died, for example, with children all from the surviving spouse, in both community property and all other property. I mean, in real estate and all other personal property. For all the community property, the surviving spouse is gonna take everything. And if this is our non-nuclear family option here in Texas Estates Code 201.003C. And we get this call quite frequently at the law firm a lot, where it's usually the surviving spouse or the widow calls up and says, hey, I bought a property with my husband. My husband recently passed away. He died without a will. I should get the whole property, my homestead property, correct? And we have to tell her, no, we're sorry. If your homestead was purchased with your husband after marriage, it's therefore community property, and the children of your late husband that are going to take half of it, and then you're going to retain half. And you get to live there forever based on the Texas Constitution, the surviving spouse homestead right, but the children own half the property ultimately, and the surviving widow is never pleased to hear that information. Personal property in a non-nuclear family situation, the children take half equally, and then half are retained by the surviving spouse. And then the next page is the single or widowed person with no children, and it gets into some different examples. And we're not going to go through all of these examples, but you have a situation where someone was widowed, single, never had any children. This section is this page is going to govern. And you've got situations where some of it goes to the father and the mother, or if one parent and siblings survive, different situations like that. This page actually gets a little complex, but once you read it and work through it and understand some of the examples, it should not be a problem. And then the final section is community property, where someone doesn't have children, all of it's taken by the surviving spouse. So Texas intestacy is extremely complex. If you have any doubts or questions, you need to call a good probate attorney. Hopefully this has been instructive in going over the form that our law firm uses predominantly, or the chart that our law firm uses predominantly, to quickly reference the Texas Estates Code and intestacy laws when someone dies without a will. Thanks for watching. If you liked the video, be sure to like and subscribe. And if you have other videos that you'd like to see, please let me know. Hopefully this has been helpful.